So dear friends, now we are going to, this is the judgment. It was delivered on 25th January, about a month back, and Honorable Justice S.M. Subramaniam, writ petition is there. I am the petitioner. I appeared as party in person. So how I won the case, my experience, I want to share it with you. And as a student of law, I want to put my thoughts, inputs. The first lecture we have talked about the analysis of the judge in the court crafting techniques, which is the last stage when you come before the judge, right? This is the Institute of Chartered Accountants of India, and then Disciplinary Directorate, Institute of Chartered Accountants of India, and this person, and this is the writ petition that I filed. Writ petition filed under Article 226 of the Constitution of India for issuance of writ of certified mandamus, calling for the records of the decision of the Board of Discipline dated 30/10/2013 and quash the same, and further direct the respondent 1 to constitute a committee of independent legal experts to examine, unravel and fix the accountability for the malified exercise of quasi-judicial powers, if any, by the respondent 2 and 3 within a reasonable time. This is the, and all the respondents were represented. So the order, before we go into the order, we would like to see what is the order passed. Beautifully analyzed. This is a case on principles of natural justice. In fact, one of my specialization itself is that, but the way the Honorable Judge analyzed the concept of fair hearing, this will be a landmark judgment on the concept of fair hearing, which is not there in the big books of Mr. Jain or anybody, and that is a very important point. He analyzed, the Honorable Judge, and it is one of the best observations I can tell you, which I will take one by one. We will analyze the judgment and how did he capture so many things. These are the next things. Order. The petitioner and the 4th respondents are directed to cooperate for conducting fresh inquiry, and they are at liberty to submit their respective pleadings, documents and evidences, including additional documents and evidences, if any, for the purposes of establishing their case before the inquiry committee. So what is that? The disciplinary committee, the director discipline is directed to take the complaint filed by the petitioner on file and conduct a fresh inquiry by following the procedures as contemplated and by affording opportunity to all the parties of being heard and pass final order, providing reasons and specific findings for arriving the conclusions. And you see, in view of the facts and circumstances of the case, this court has no hesitation in forming an opinion that the case deserves to be remanded back to disciplinary authority for conducting fresh inquiry, and following order was passed. The impugned decision of the Board of Discipline dated 30/10/2013 and all the other consequential proceedings are quashed. The disciplinary committee, see, this is the order I have got. So in other words, whatever I pleaded for has been allowed. And how did this happen? How did this happen? Now friends, first step is, I don't know how I will take the case for a student of law. I am only focusing on the student of law. Writ certified mandamus, you must understand, it is an Article 226 of the Constitution which gives a judicial review power to the Honorable High Courts, and it is a wide power. Wherever there is a miscarriage of justice, then the court can step in, and in this case mandamus will not be maintainable because the decision has already been taken. The executive, the disciplinary authority, is entrusted with the quasi-judicial powers. So there is a procedure laid down for disciplinary proceedings against the members of the profession, and they have followed that procedure, whatever is that procedure or not, and they have to comply strictly with the principles of natural justice, and then they have to come out with the order. And in this particular case, you have to establish this, that judicial review is a process. The decision making process is coming under the scanner. The court will only go through the process followed by the inferior court in coming to the judgment conclusion. Whether the procedure followed by the quasi-judicial authority below is challenged against the violation of principles of natural justice, violation of fundamental rights, and violation of any statute, then the court will interfere. Unless you are able to bring that into the system, telling facts, oh this happened, that happened, no. I will show you how I was, in the case of mine was about to be dismissed, let me tell you first, but then we were able to survive and get back to this case. So, what is the case? And if you see also, the learned judge, honorable judge, 23 pages he passed the order, capturing entire facts in short. That's the greatness of the order. We'll see the order, how we analyze the case. The greatness of the judge is the entire case that has happened so much, he captured it and he was able to filter it and then make it as order. It's an extraordinary analysis, but how to make the judge do that? It starts with convincing the judge that you have a case, first step. That is in a writ of certiorari, how to convince it, that is another point. Second thing is, when the matter is reserved for orders, the learned judges, please remember, all of you, you must give a written submissions in such a way that the judge can just come to a conclusion. Here only there is lot of problem most of the students, lawyers, young lawyers face. Whatever you speak, the judge need not remember. Nobody can remember. It's humanly impossible to remember. You understand? Generally what happens is, judges will have assistants of court officers, law research associates they are called. They will be youngsters. So judge would have told them, this is how this case, please prepare the order. Then the judge will go through. But here, this is the judge himself passes the orders. There are two types of judges. One judge will pass the order sincerely, loves. We have seen it in tribunals also. But another type of judges, majority of the judges, humanly impossible task. Then what they will do is, they will tell the law research associates or the court of that persons that he is expecting, he is going to allow the case or dismiss the case, something like that. Then he will tell them, you please prepare the case based on the findings. The typed set, this is almost 400 pages typed set we have submitted, they have submitted another 300 pages. So how do you bring that? Today I have learnt it, friends, today, not in 2013. So let us go to the next stage of how the pleadings took place. I will explain. Live case study, this is my third stage. I am trying to explain. I am trying to bring it as a live case study. And what do you mean by live case study? What all happened? How proceedings have taken place? So for this I am going to take you through the facts of the case